All right, so am I able to leave everything only to my kids of my first marriage, for example, and exclude my current wife and especially my first wife? Is that a scenario possible in drafting up a will?
It's possible, but you've decided to leave your estate to the kids of your first marriage,
yep.
But not to give anything to your current wife or your former wife. Your current wife and your former wife would both have a claim against your estate because they're both eligible under the Succession Act to make a claim on the estate. They would have to prove that that you should have given them more in order for them to live appropriately in the future. And although the ex-wife would have probably a few more difficulties depending on how long she's been there, the current wife would probably, depending on the circumstances, but in ordinary circumstances, would almost certainly be successful in a claim. The family provisions laws are all about the fact that the state believes it has an interest to ensure that people look after their relatives, because if they don't, those relatives become a burden on the state. So you don't want people whose parents have got a reasonable amount of money to not get any of that money and to therefore end up using social services. So that's the theory, anyway, behind family provisions laws, and they exist in every state in Australia. The only thing that differs about them is how they. In New South Wales, we have particularly ferocious family provisions laws. They're the worst, quote unquote, in the country, because we have something that's called the notional estate, which I won't bore you with too technical. But essentially, our family provisions laws are very strict and very stringent, and the potential is that if the court believes that someone could have been enhanced out of the estate and should have been, then they'll certainly make an award.
Peter, if Eric tells George, that his time's almost up, and George decides...
It's only quarter to 7.
Well, Eric said he could tell us all when our time was. So if he's telling George his time's almost up, and George decides to actually give his money away prior to passing away, can that still be contested?
Yes, it can. However, there's a clawback period. You have to, if you want to give assets away, they can claw back anything within 3 years of your death. So any payments or gifts outside of the estate within the 3 years prior to your death are captured, and they can claw that back. Good question.